Let's get started here. Welcome to episode 5 of Dark Academia with Rich. This is the Charlottesville trial special. If you're not aware or forgot, I'll give you a brief refresher. Charlottesville was an event in August 2017. It was called Unite the Right. And it was a rally. There was many things. The initial impetus was that there was a park in there was a statue of General Lee in a park called Lee Park. That was later renamed Emancipation Park at some point. At the time, it was Lee Park. The city of Charlottesville had declared themselves basically an activist stronghold. Somebody, either officially or somebody who was affiliated with the city government, either city council or some city official, said that they were like the epicenter of the resistance to Trump. Remember all the resistance stuff and all the Star Wars, imagery that was being thrown around by the left, the blue wave, the resistance, yada, yada, yada. So they declared themselves to be this, the epicenter of the resistance, this sort of bastion of progressive liberalism. And they were really caught up in what has been sort of widely called Trump derangement syndrome, right? There are some different characters. I'm not going to get into all the city council members and all of that stuff, but at some point they voted to remove Confederate statues. This is Charlottesville, Virginia, southern town. It's a very lovely place. University of Virginia is there. I really like the city of Charlottesville. Aside from the politics of the people there, I have nothing bad to say about the town itself. It's a beautiful place, and if you're ever in the area, I encourage you to stop, walk around downtown, go up and down the mall, look at the shops, grab a slice of pizza. It's an idyllic little town, the kind of place I imagine you'd want to raise a family or spend your time. So this place declared themselves epicenter of the resistance. Want to remove the statues. So Jason Kessler was a resident of Charlottesville at the time. I believe a graduate of University of Virginia. He decided he's going to have a rally, essentially in support of white history, Confederate history, of keeping this statue and others like it intact. This was early on in what would become a pattern of removing first Southern heritage, Confederate generals, those sort of people. But then, as many people, myself included, noted that it wasn't really ever about the Confederacy, and it would not stop there. This was kind of about something larger, I believe, and I think have been proven correct, that this is about erasing white men and white society, and any reminder to the other races that we had a nice society that was great once. So Jason Kessler wants to have this rally. He goes and gets a permit for the rally and starts inviting some other groups and people there. Richard Spencer was one of the people, also a UVA graduate as far as I know, who was invited. There was a whole host of people there, and I'll just name, I don't know everybody who's there. I wasn't there. I watched it from home in live stream. It was very interestingly enough, it was happening right before my law school orientation was set to start. I knew some people going. I thought it would have been cool to go, but looking back, it was probably very prudent not to have gone. So he invites all these people, League of the South with Michael Hill, Michael Tubbs, some of the Daily Stormer people are invited. Asmodor, who was a Daily Stormer writer and contributor, was there. There was the Traditionalist Worker Party, which was Matt Heimbach and Matt Parrott's deal. There was Identity Europa, Nathan D'Amigo, of his thing. There was Elliot Klein of, I'm not sure who, he went by Eli Mosley, but he's Elliot Klein, and he was there, part of it. All these groups, probably dozens, right, show up. Hundreds of people, if not thousands of people show up for this rally. As you guys all probably know, there was a torch march rally the night before, kind of a secret one. And then there was the next day, there was a bunch of speeches that were set to happen. Well, chaos ensued. I guess I can get to whose fault it is now, kind of laying in the background. Chaos ensued. There was an independent report commissioned after the fact, which has become known as the Heafy Report. And the Heafy Report basically revealed that the Charlottesville mayor and police were totally indifferent to anybody's safety, even people who they were sympathetic with. They thought they were just going to be indifferent to the safety of the Unite the Right attendees. There's some statement in the Heafy Report where it's either the mayor or the police chief. Some official says something like, I don't care if they get in and out safely or not. It was the testimony and trial of Jason Kessler, Matthew Heimbach, and some others that they communicated with the police in Charlottesville, trying to figure out a way to get to the garage, from the parking garage to the park safely, what routes they should take, that sort of thing. There was a breakdown of communication at some point. Long story short, fights broke out throughout the whole day. Antifa shows up. They throw frozen bottles of piss, rocks. People are pepper spraying each other back and forth. There's one guy named Corey Long makes a homemade flamethrower, is flamethrowing people trying to get in and out of the park. A guy pulls a pistol and kind of fires a warning shot at the ground next to this guy. There's a vicious attack by a black fellow named DeAndre Harris, goes up behind a guy, an older gentleman who's attending Unite the Right, and clubs him with something, busts his head open, sprawls him out in the parking garage. That guy goes to trial, DeAndre Harris, the black guy who attacked this elderly white man. It's on video. It's filmed. He gets exonerated of these charges. After that, several guys from Unite the Right attack him in retaliation for, you can call it retaliation, you can call it stopping further threats, self-defense of another. They ended up being charged with it. 4 guys or so ended up being charged criminally, put in prison in some of their cases, I believe maybe all of their cases, for attacking DeAndre Harris after DeAndre Harris just clubbed a guy from behind. You have James Fields trying to leave, turning down a street that was supposed to be blocked off. His car gets surrounded. People are throwing stuff at his car, beating on it. He hits the gas. Heather Heyer ends up dead. Bunch of people go flying through the air. Somehow a helicopter crashes. A police helicopter crashes somehow. I have no idea. I didn't see anything about that in the Heafy Report or otherwise. I've never really seen a follow-up investigation. I'm sure the NTSB or somebody did something, to figure out what happened as they normally do, or some aviation group. I think the NTSB is the safety board, right? Is that it? Correct me in the comments if I'm wrong. But in any event, you just have chaos ensue in this small southern kind of college town, right? That's the background. All right, so here we are. We want to have a rally. Jason Kessler goes and gets a permit. The city tries to pull the permit, by the way. He gets the ACLU involved. He pleads for the ACLU to help him. They do help him. They win, get their permit reinstated. All these people end up injured on both sides. People get maced, pepper sprayed. Nothing catastrophic happened to anybody with the exception of people involved in the car accident James Fields was involved in. That's important, I think. I think that's important, as we'll get to later. So what happens? This makes national, international news. Heather Heyer's dead. Trump's in charge. Trump's in charge of the country. You know, he makes this statement about there was good people on both sides. It's a tragedy Heather died, blah, 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 whatever he said. People are just totally enraged. Enter a lawyer named Roberta Kaplan, New York City big law attorney. Roberta Kaplan had just left big law and started her own boutique law firm called, is it Heckler, Kaplan, and Fink? I believe it's Heckler, Kaplan, and Fink. That law firm is based on the 63rd floor of the Empire State Building on the 5th Avenue side. Some of the most expensive, prestigious real estate in the world. She has sued. She's involved in a lawsuit. I believe there was one. Let me double check. I believe there was one. Well, there were several. I don't want to misspeak here. But in any event, I'll just tell you that Roberta Kaplan and her law firm, since it started shortly before Unite the Right, sometime in 2017, has been involved in some high-profile litigation that some people might call lawfare. She gets the idea. She's watching this press conference or something, as the story goes, about this Unite the Right thing, and she says, let's sue the Nazis. And she calls up some of her friends and, you know, some of her girl boss friends and says, hey, girlfriend, do you want to sue the Nazis? And they say, yeah, I've always wanted to be a 21st century Nazi hunter. That's how the Rolling Stone characterized one of these other women that's involved. So they get this idea to sue the Nazis. They start looking for plaintiffs. Somehow these plaintiffs who have various smattering of injuries, allegedly, some real, some alleged, get hooked up with Kaplan. And they start finding ways to sue the Nazis. The Discord leaks happen. Somehow Unicorn Riot gets a hold of a bunch of Discord posts from these guys who were organizing Unite the Right. Gets over to Kaplan. They start putting together this lawsuit against the organizers of Unite the Right, okay? So that's where we are. Around the same time, an entity called Integrity First for America forms. It's a nonprofit organization. The executive director, another woman of the persuasion who celebrates Hanukkah, named Amy Spitalnik, I'm not sure the pronunciation of her last name. She heads up this Integrity First for America that does fundraising in order to sue the Nazis. They came up with the hashtag Sue a Nazi, I'm sorry. And every interview Amy Spitalnik gives, every sentence she gives in every interview, she talks about accountability. There needs to be accountability for these people who organize this. There needs to be accountability for this violence, accountability for this, that. My personal opinion is that these people don't believe in accountability for violence so much as they believe in accountability for speaking ill of Jews and other non-white races. That's my personal opinion on the thing. If you read beneath the surface and between the lines in all these interviews, you know, they'll say there needs to be some accountability for all this violent rhetoric and white supremacy, and also some people got injured. And it's always kind of tacked on. It's always sort of an afterthought, the way I read it. It's not so much about getting money for people who are allegedly injured. This seemed to be a way to punish political enemies of what these people believed to be political enemies, not only electorally, but racial enemies. It seemed to be not just political. There is this veneer of, Trumpism and whatnot. But what really seemed to enrage these people was the chants like Jews will not replace us, blood and soil, white lives matter, that sort of thing. And those were my suspicions going into the trial. And then seeing the trial, a lot of those suspicions, for me at least, were confirmed. So let's talk about integrity first for a little bit. They have several 990s they've published they're public information that I went through. A 990 is when a nonprofit organization operates. When you form a nonprofit, you have this agreement with the government. And the agreement is sort of like, you don't tax me. In exchange for not taxing me, I will provide some information publicly that wouldn't otherwise be available. So if it was just a private entity, private entities don't have to publish how much their income was, what are their expenses, or that sort of thing. But nonprofits, they have to publish a certain amount of this. And a little bit more can be discovered by making a formal request with the entity. So you don't have to publish your donors list, for example, but if somebody were to inquire as to the donor list, I believe that for most nonprofits that needs to be forthcoming, at least like the 501(c)(3)s. So anyway, so I'm looking at these 990s, their filings. They get several $1 million in 3 years. They take in close to $20 million. Now on these 990s, it doesn't say exactly who the money comes from. In some articles that I've not verified, I've seen a couple places. The ADL is one donor, but allegedly in the article I saw, it said the ADL was only in for about $100,000, which is a small fraction of this $20 million raised in 17, 18, and 19. I don't know how much was raised in 20 and 21. I haven't seen those 990s. Allegedly, there was another organization that donated, which was the Open Society, George Soros' Open Society. Again, that came from an article in the mainstream media, but I haven't confirmed it because I haven't seen the donor documents, which are available if you request them, but they're not public like the 990s are. So you have millions of dollars coming in from somewhere for them to pursue this lawsuit. So the lawsuits get started. The theory of the lawsuit is interesting. It's novel. It's the initial complaint was over 100 pages. This is just a behemoth of a lawsuit. First of all, an opening complaint over 100 pages, over 1,400 docket entries, 1,300 docket entries, I believe, before juror selection started. 1,300 docket entries. It represents a whole number of things, all sorts of motions to dismiss, responses to motions and dismiss, replies to responses to motions, SIR replies, amended complaints, on and on and on and on. Every sort of thing you can imagine happening procedurally in a federal lawsuit happened here. So over the course of the 4 years leading up, you have over 1,300 of these entries, and each one is potentially important. Not each one is important to all parties, but each one is potentially important to any one party. Maybe one would be Richard Spencer's motion to dismiss. That's an entry. And then an entry is Kaplan's response to his motion to dismiss, arguing why it shouldn't be dismissed. And then his reply to their response. And then the judges, or then maybe some amended response somewhere. And then the judge's order on it. And then on and on and on for every little thing, okay? Motions for sanctions, all kinds of discovery things back and forth. Total beast of a lawsuit, okay? So when the complaint actually comes, you see Kaplan and some other attorneys joined. Some attorneys from Paul Weiss, huge law firm, Cooley, huge law firm. They joined in as well. They had dozens of lawyers entering for the plaintiffs, mostly from New York. You had Karen Dunn from Paul Weiss. You had Alan Levine from Cooley. You had Michael Block from Kaplan, Heckler and Fink. Those were kind of the big guns on their side. And man, they are, you know, I don't have anything. I have a lot to say about, Kaplan, Levine, Block, and Dunn. But one of the things I'll say is they're all high functioning and competent people, and they know their way around the court system very intimately, and they're good at this. So at one point, Alan Levine, I believe, was on the chair of the Anti-Defamation League. He's heavily involved in Jewish ethnic activism. There's some other Jewish organizations he's on the chair of, or on the board, or something of that sort, or is the chair or on the board. He's heavily involved, and he has been for some years. He's a partner at Cooley. He's a real heavy hitter. Block is probably the newest one of these people, but very competent, knows his stuff. They're the people involved. They recruit all these plaintiffs. So they recruit a smattering of plaintiffs. I'll get to them in a minute. Let me just tell you what the lawsuit was about, what it alleged. The general facts in this massive 112-page complaint are that there was a conspiracy. They alleged a conspiracy happened between the organizers of Unite the Right. That they wanted to go to Virginia, to Charlottesville, not just to protest in favor of free speech or against taking these monuments down, but they had the intent, and it was their purpose, to go down there and cause racially motivated violence. So this they brought a couple old laws into this, known as the Ku Klux Klan Act. It's 42 USC 1983, 85, 86. And they brought a claim under 85, which is basically planning to commit racially motivated violence or depriving people of their civil rights. It wasn't ever clear what civil rights they violated. Historically, this might be something like a famous case would be the Freedom Rider cases. There was these guys, 2 Jews and a black guy, going around getting blacks registered to vote. The Klan killed them. The FBI then brought in. This is a really horrific story. It's a really horrific story, and it's really troublesome. The FBI hired an ex-mafia hitman to bring in. They brought in some of these people affiliated with the Klan who they thought might know about these murders, about the Freedom Rider murders. So the FBI hires a mafia hitman to torture private citizens in the South, to give them information on what happened to the 2 Jews and black guy. I think that's way more disturbing than the fact that the 2 Jews and the black fellow ended up dead. To be honest with you, it's one thing if some people are going to kill each other. It's a whole other thing to have the FBI, federal government, hiring a hitman, send it into this little town and torture people to get information out of them. So that's a little side note. In the 60s, a lot of people don't know, but everyone knows about Mississippi burning and the Freedom Rider thing, but a lot of people don't know that the way that case was quote-unquote cracked was that the FBI hired mafia hitmen man or men to torture people to get information. So, I'm sorry, that was a total aside. So, but the Ku Klux Klan Act could have been used there because the argument is that they were depriving these people of their right to vote and right to go around and engage in the voting process and register people to vote. So it was an obvious right. Or say someone's going into a poll and you're standing there, you know, some KKK guy standing there with a rifle and says, no blacks are allowed to come in here and vote. That would be deprivation of a civil right. Or, you know, black people are engaging in a protest and you show up with the plan to shut their protest down violently. That might be an invocation of the Klan Act as it was originally intended when it was written. And when it was written was shortly after, well, in the Reconstruction period. What was going on is there was a bunch of freed slaves and they were running around causing some havoc. The Klan formed. Local governments and police weren't doing anything about the Klan sort of being this extrajudicial policy of a neighborhood patrol. They passed this Klan Act federally. It enabled federal government to go after these people, basically, if the local governments wouldn't. There was instances where people were on the police department and mayors who were part of the Klan, and then this is how you get the Klan Act. So fast forward, 150 years. You have guys in Charlottesville like Matt Parrott, Richard Spencer, Nathan Domingo, Jason Kessler getting charged with the 2 counts under the Ku Klux Klan Act. 1, the conspiracy to deprive people of their civil rights, and 2, which is interesting, it's the 1986 section, which is if you know about a conspiracy to commit racially motivated violence, you have a duty to try to stop it. And this is different from conspiracy generally of a crime. Generally, if you know of a conspiracy, you don't have to go snitch on anybody. But they've made it illegal, at least civilly, to not snitch on somebody. If you know and don't do anything to prevent it, and they find out you knew, they can sue you. The parties can sue you. The alleged aggrieved parties can sue you under 42 U.S.C. 1986 for monetary damages. Now, normally, if there's a civil conspiracy and you know about it, okay, you don't have to tell anybody. If you were involved in it and you want to get yourself removed from the conspiracy, you have to take affirmative steps to stop the conspiracy. And that's the only way to limit liability, like criminally or really civilly, is to affirmatively remove yourself and affirmatively try to stop it. You can't just halfway through like a bank robbery decide, ooh, I don't want to be involved anymore. And then if somebody dies during the bank robbery, you're still going to be liable for everything bad that happened, the bank robbery, the murder, anything that was foreseeable from it. So this is very different from traditional kind of conspiracy law, which I think a lot of this stuff is, I don't really believe conspiracy should even be illegal itself. You have to take some affirmative act towards the conspiracy, but the underlying crimes are always illegal. A bank robbery is illegal. Why should conspiring to do the bank robbery make it more legal? It's one of those things that is like hate crime laws and terrorism laws that I frankly don't believe in. I think it gets too close into like, let's try to understand the person's intent and criminalize it further. It's already illegal to like blow up a subway station or fly a plane into a building, right? It's already illegal to murder somebody. Why these things like terrorism and hate crime are trying to make certain thoughts illegal? So it's like if you kill somebody because you want their shoes, that's just a murder or a felony murder maybe. you know. But if you kill somebody because their skin, it's more illegal because you were thinking bad thoughts. It's saying that if you kill somebody because you don't like their race, that's worse than just killing them because you wanted their shoes. And I don't think I agree with that. But that's just another aside that you know, get my thoughts on since we're doing this. Really appreciate y'all being here, by the way. A lot of people just want like the snarky hot takes and that kind of rubbish, and you know, you guys are like doing deep dives into the history of United States code, and that's cool, you know. So those are the first two claims. Those are the big whoppers. These KKK, and it was sort of their flagship claims, and what on all the interviews Amy Splatonic did for Integrity First for America and Roberta Kaplan did, there was always hitting these KKK. It's the big, sexy, like, we brought up this 150-year-old thing, we went through the books, we dusted off the old books on our shelves, got this old Klan Act, looked through the cases, you know, here we are. The other claims are less sexy. Count 3, civil conspiracy. Basically, if you conspire to do some crimes and you hurt people, you can be sued civilly. The underlying crimes alleged that these plaintiffs allege the defendants conspired to do were things like ethnic intimidation, which is basically just a harassment or a disorderly conduct with an ethnic or religious flair. So if you get up in someone's face and you're just being like really aggressive and hostile to them, and you put them in fear of being hurt, they could be charged criminally with like a harassment or disorderly conduct or disturbing the peace, whatever is on the books in the state with that. They could be sued civilly for like an assault claim, a tort claim. But if you do that and you use one of the magic racist words, now it's like a little more, okay? It's an ethnic intimidation. So there was a religious vandalism thing. They got charged with causing or producing a riot, inciting a riot, public inconvenience, annoyance, or alarm, which is a standard kind of disorderly deal. Assembling a collection of people with the intent of committing or actually committing assault and battery on another person. That's a weird one. It's Virginia code. Another, assembling a group of people for violence. Kind of weird, but whatever. I think those are probably, I don't know the origins, the legislative history of why Virginia has these, but they are. Maliciously causing another person bodily injury by the use of explosive or fire. Okay. That's, some of the laws are weird. Like, it's already illegal to hurt, like, you can't just go around hurting people, right? But it's weird that they have a separate code for if it's explosives or fire versus if you just took a baseball bat to them. It's just a quirky law. I don't know what happened at some point in history that they did that, where like a standard battery or assault wasn't enough. It was like, you know, okay, you hit him with a crowbar, that's this. If you burn him with a tiki torch, that's this. There was allegations of tiki torch burnings. Burning an object with the intent to intimidate the private property of another. This is probably an old cross burning statute, and there's a Supreme Court cases on cross burning and free speech, and this is probably getting around. There was a time when the Supreme Court went back and forth on like if you can or cannot burn a cross and what it means, and that's probably that. There's a weapons charge in here. There's a solicitation to terrorism charge here. There's some terror charges. Providing material aid to an organization who's committing terrorism in further of the individual's objectives. So let me explain that one real quick. Aiding and abetting terrorism generally means that, okay, it doesn't mean, I'll tell you what it doesn't mean first. It doesn't mean if you give somebody money or aid and they turn out to be a terrorist, that doesn't mean you aided and abetted a terrorist legally. Okay? In order to meet the standard of aiding and abetting a terrorist legally, you had to give them the aid with the intent that they would use the aid to carry out a terroristic objective. So if somebody comes to you and they're like, I am a terrorist and I need some money for books to put my kid through school, will you help me? And you give them money and they do use the money for books for their kid, you're okay. If they lie to you and you gave them money and they turn around and use that money for terrorism, you're still okay technically because you didn't intend the money to go to terrorism. You intended the money to go to books for a school child, okay? So you have to intend for the aid, training, whatever, to go towards the terroristic activity. I believe that is for if it's a domestic terror organization, and there's a distinction between foreign terror and domestic terror organizations. And a note on those, they're called FTO and DTO is the shorthand. Whoever is on the list of foreign and domestic terror organizations, it's largely a political. It's not largely. It is a political list. It changes based on whose administration it is and whose Department of Justice it is. So you would think there would be some objective standard to determine who's a terrorist and who isn't. There's not. It's just like whatever the current administration wants to put on there. Great country, yeah? So back to this complaint about the Charge 3 conspiracy. The reason I'm going over Charge 3 so much is because that's the one that they ended up being found guilty of. So it'll give you some more context later. There's a slight method to the madness here. Okay, a general assault charge and a general battery charge. So engaging in an overt act that is intended to inflict bodily harm or intended to place the victim in fear of bodily harm. That's standard tort assault. So assault in standard tort language means you place somebody in fear of being attacked or harmed. They don't actually have to be attacked or harmed, but they can be. So if you're coming at somebody with a bat and they're like, oh shit, I'm about to get my head beat in with a bat, that's assault. When you actually hit them with a bat, that's battery. If you came up behind somebody with a bat and hit them and they had no idea you were ever going to hit them, you technically didn't assault them because they were never apprehending or fearing your imminent battery. They just got battered with no awareness. Little fun fact about assault and battery. All right. That's claim 3. That's the big state conspiracy deal. So it's a conspiracy to commit crimes, and these are the crimes or torts we just went over. Count 4 is a negligence count, and it is only leveled against Mr. James Fields, only by the plaintiffs who were hit by his car or nearly hit by his car. I'm not going to go into details on that. It's pretty much just what I said it is. Count 5. Count 5 is several of the plaintiffs against several of the defendants. It's for racial, religious, and ethnic harassment. I talked about that earlier. If you get in someone's face, screaming at them, call them a no-good, low-life scoundrel, yellow-bellied, mama wear army boots, okay, you're harassing them, right? But if you say one of the magic words, now we got ethnic harassment, okay? Count 6 is assault and battery related to the car accident. The other assault and batteries, for the purposes of understanding this lawsuit, just assume they happened at some point on August 11th or 12th in 2017, not related to the car accident. So this 6 count, it's assault and battery, you hit me with your car. Count 7, it's intentional infliction of emotional distress, called IIED generally, just usually abbreviated. This is, again, leveled only against Mr. James Fields by April Muniz, Elizabeth Sines, Marissa Blair, Marcus Martin, Thomas Alvarado, Chelsea Alvarado, Thomas Baker, and Natalie Romero. They got hit by the car, almost got hit by the car. What this is saying, IIED is a claim, and it means somebody through their actions who are so extreme, so over the top, did something to inflict emotional distress upon a person. It has to be extreme and outrageous conduct is kind of the magic legal words here. Extreme and outrageous conduct with the intention of emotionally distressing a person. Those are the 7 claims here. It's a lot. So let me explain a little bit of a procedural thing in a huge case like this that a lot of people were asking about. You have 9 plaintiffs on this side. You have 7 claims here. You have like 20 defendants here. It's not an all or nothing thing. You can match it. Remember those things, those like tests in grade school where you'd match definitions and like it had to go zigzag in every direction? It's sort of like that. So they could find that for the plaintiffs who had their claims against James Fields, they could say some of the claims against James Fields were legitimate to some plaintiffs, but not all. So maybe there's one where it's like 5 people on count 6 against Fields, and they could find for 3 of them. As far as the in theory, count 1 and 2 ended up being a hung jury, but let's just say they weren't, for the sake of being thorough. The jury could have found that Jason Kessler and Richard Spencer conspired to deprive these people of their civil rights through racially motivated violence, but none of the other defendants. So you could have had a couple defendants guilty of a couple counts to all plaintiffs. Or, in a couple cases, what happened, they could say, I think the defendants were guilty but didn't injure all plaintiffs. So not all plaintiffs will get any awards. So it's a real mix and match. It's not an all or nothing to any of these claims. So it could have been a thing where like one of the 20 defendants, I don't know if there's 20 exactly. I don't know exactly. I'd have to go back and read it. There are other parties that I didn't mention. I'm sorry. There are other parties named in this lawsuit that I didn't mention because they did not participate whatsoever in the trial. I don't believe they even participated in discovery. Elliot Klein, used to go by Eli Mosley, was one of those parties. Augustus So Invictus, I believe, is another one of those parties. A couple chapters of the Ku Klux Klan did not participate. There was Vanguard America and a couple representatives that I don't believe participated much. Give me one second. So the reason I don't know the exact number of defendants is because of that. I'd have to go through and count them all. There's a lot. All right. So you understand. Let me see where we're at. Let me pull up my notes real quick. Let's see how much time. Oh my gosh, I've already been talking for way longer than I intended. Holy cow. Okay. So got the background, the complaint. I told you about the plaintiffs, told you about the lawyers, IFA. You know about the defendants. But let me tell you a little bit about the plaintiffs, I guess. Let me give you a quick rundown on the plaintiffs. I'll just give you a quick rundown on some fun facts with each plaintiff, okay? Oh, my cat just is going crazy. There's a cat that comes around to visit my cat, and for some reason my cat like hates this other cat and always like attacks the other cat who seems friendly through the glass. I have some, yeah. All right. So here are the plaintiffs. There's Devin Willis, who was like the leader or a secretary of the Black Student Union. He was a student at University of Virginia. He's like a blacktivist, okay, kind of a militant blacktivist. Seth Wispelay, he's the Antifa reverend who doesn't think Jesus is without sin. Really bizarre guy. Gives off serious sex pest vibes. There's Natalie Romero. I believe it was Romero. Could have been Alvarado. Pretty sure it was Romero. She was also an activist who went to a bunch of rallies like Devin Willis. She was a part of this like a legal alien organization that fights for amnesty and for like money for them, for money for whatever for illegal aliens and their families. There's April Munez, Thomas Baker. Thomas Baker is the white guy flying through the air with the big back tattoo, big tramp stamp, in the famous photo of the Dodge Charger going through the crowd. The other person in that famous photo is the black guy in the red Jordans. That's Marcus Martin. Marcus Martin was engaged to Marissa Blair. Marissa Blair is now an attorney, I believe. Chelsea Alvarado, I believe that was another student at UVA. Marissa Blair, I don't know if she was a law student at the time. Marissa and Marcus, again, they were in a relationship. They got married and then subsequently divorced. They got married after Charlottesville and then got divorced within the last 4 years. They were friends with Heather Heyer. Elizabeth Sines, the lead plaintiff here, was a student at UVA Law. She didn't get very much money. She got the least amount, it looks like. Her claims essentially were PTSD. And I'll talk about I'll talk about the plaintiffs, might as well. So they all alleged a number of things. Some alleged they were actually hit by the car, and some were actually hit by the car. Thomas Baker and Marcus Martin were very obviously hit by the car. A couple of the other ones were hit by it too. Some of the other ones, some of the other plaintiffs are only alleging emotional distress. So Elizabeth Sines, several of them, Devin Willis is another one, Seth Wispelay. Well, Seth Wispelay claimed he was knocked over by a shield. So several of them, sorry, lost my train of thought. Several of these people are claiming they only had PTSD and emotional distress. They brought their shrink in as an expert witness to testify that all these people were tested and that they all had severe PTSD in the highest category, the 99th percentile of PTSD. And the people who were hit by the car, and the people who were not hit by the car, and the people who didn't even see the car accident all had the same level of PTSD. The same level of PTSD that like people who, were in war zones, have been raped, have been subject of traumatic home invasions would ostensibly have. Also have the same level of PTSD allegedly as these plaintiffs who saw a Torch March rally and saw a car accident. Very bizarre to me. Marcus Martin, the black guy who's testified at length about his Jordans getting ruined because there was blood all over them. He was very concerned about his Jordans. They were a gift from his fiancée. Very hard to find. I'm not sure what number Jordans. I don't know. Probably 7s. Just making that up. I don't know anything about Jordans. He was on probation at the time. And his fiancée said that we probably shouldn't go because it could get violent and you're on probation. But he said, nah, baby, don't worry about it. Let's go anyway. The reason he was on probation is Marcus Martin was part of a duo who had been committing very violent and horrific home invasions in Charlottesville. Marcus Martin, the black guy flying through the air in the red Jordans, they got hit by James Fields' car, was going into people's homes, tying them up with duct tape, stripping them naked, pistol whipping them, pointing pistols at their heads, and taking all their stuff. And he was out in no time at all and on probation. So that's the kind of people like James Fields is running into with this car, who are blocking his way. You know, make whatever you want with that. Let's get to the trial a little bit. Juror selection was interesting. There was a lot of questions on the juror pool about their feelings on race, about Antifa, about Black Lives Matter. There was a significant number of people in the juror pool who hated Antifa, hated Black Lives Matter, and wrote that in the questionnaire that they were very concerned about racism against white people. Unfortunately, not many of them made it on the jury. I'll get to that in a minute. Jury selection is a little bit complicated. You get this huge pool of jurors and you try to say who's qualified. So people can like disqualify themselves by saying things like they cannot be impartial and they will not be impartial. If somebody says something like that, one party, if they want them, can try to rehabilitate the juror. What that means is they will say things like, okay, are you sure you cannot be impartial? Now that you're here, do you think maybe you can go ahead and be impartial? And they'll say yes or no. And if they say yes, great, they're rehabilitated. If they say no, they get struck for cause. The judge will strike them, get them out of the jury pool, and basically say they cannot be impartial. Or some of these people had financial strain or child care issues or whatever. For whatever reason, they would be struck for cause. There's also a thing called peremptory strikes. If the juror is not struck for cause, but you don't want him on there, you can use something called a peremptory strike. Each side in this lawsuit had 6 strikes. You can use it for anything you want, sort of. After a couple day 2 of juror selection, a couple of strikes were used by each side. The plaintiffs, Kaplan, Dunn, Levine, Block, they charged the defense with something called a Batson challenge. And Batson is a case where a lawyer struck somebody off the jury because of their race. It was a racially motivated case and you didn't want blacks on the jury. Something along those lines. I haven't read the case in a long time. Goes up to the Supreme Court. The Supreme Court says you can't do that because people have a right to serve on the jury. And if a juror is struck for their race, that's an impermissible hindrance on their right to serve as a juror per the 14th Amendment. Got that? If you challenge somebody and the other side thinks it's based on race, they can challenge it, and if the judge believes they were struck because of their race, even partially because of their race, they can reinstate the juror, and then the party who struck that person loses the strike. So the plaintiffs tried that. The Batson challenge was heard after all the strikes were used. I think the defendant struck 2 blacks and an Asian and then 3 whites. They didn't like this guy because he was a blacktivist. He was like this black agitator type, right? And he was like involved in some black activism, BLM stuff and whatnot. So they didn't want him because they didn't want him commandeering the jurors and trying to get him, making things about him and making this about a broader racial issue. And that's why he was struck, because he was heavily involved in left-wing pro-black nationalist activism. The plaintiffs allege he was struck because of his race, so then you have to have a hearing about it. Long story short, the judge did not believe that the defense struck this juror because of his race, so he remained stricken. 2 lawyers brought up a really interesting fact. One was Josh Smith for Trad Worker Party and Matt Heimbach and Matt Smith, and the other one was Brian Jones for Michael Hill, Michael Tubbs, and League of the South. And he brought up the fact that these plaintiffs' lawyers, who all happen to celebrate Hanukkah, he didn't say that. That's my addition. Used all 6 of their peremptory challenges on white people. All 6. So he said, maybe we should charge you with Batson. There's blacks here. There's been Asians. There's been Latinx. There's been whites, and he used all 6 on whites. We used 2 on blacks, 1 on Asian, 3 on whites. You're a bunch of Jews striking all the white people. Do whatever you want with that information. I'm not going to say anything else about it. So then you get to opening statements. Opening statements on both sides. Plaintiffs' opening statements were essentially, these are a bunch of bigoted, racist, came here to hurt blacks and Jews. There were no Jewish plaintiffs that I know of. And as far as I know, no Jews were hurt. But the plaintiffs constantly brought up the anti-Semitism. They made it. The plaintiffs' attorneys made this case about themselves and about the Jewish race broadly, more than about the individual plaintiffs in many ways. After opening statements, you had the plaintiff's case in chief. Part of which that case in chief was bringing in expert witnesses. One was Deborah Lipstadt, who wrote the book Anti-Semitism Here and Now. She's allegedly an expert on anti-Semitism. Her view of anti-Semitism is anti-Semitism has been around for thousands of years. It is entirely irrational. Jews have never done anything to cause anti-Semitism. Through time and space, across languages, oceans apart, people of all races and religions throughout many periods throughout history have come to the same conclusion on the Jews. And it's that they dislike them. And all of those people, separated by space and time, and by language barriers that they could never possibly reconcile, came to the same incorrect and irrational conclusion. The same ethnic group, the same small ethnic group, that make up the same minuscule percent of the global population, from a small patch of land on the other side of the world. They're the only common denominator. But it's all the other people who have this irrational hatred for no reason. That was Deborah Lipstadt's expert testimony. She also testified to some things like what 1488 means, and that all these people are secret Hitler lovers. It was very funny because people like Matt Heimbach rendered her testimony quite worthless when he got up on the stand and said he loves Hitler. So you had this expert witness there to show the jury that these people are secret Hitler lovers. And Matt Heimbach got up in there and said, there's nothing secret about it. I'll tell you right now, I love Hitler. Let's talk about Peter Simi. He's an expert witness. He allegedly studies white supremacism. He's allegedly studied them for 20 some odd years. He's a really weird little freak. He was raised by a single mother who used to make him watch Roots and PBS documentaries on the Klan. According to interviews with Peter Simi, he started carrying around a book when he was 10 years old documenting instances of what he calls everyday racism. Somebody would make a comment about blacks being criminals. He would jot it down in his little notebook as a 10-year-old. Like a weird little Stasi, you know? So his expert testimony amounted that nothing white supremacists say is truthful. They constantly engage in front stage, backstage behavior, which amounts to what you would normally call impression management or maybe public relations. So he says when people say, when white supremacists make jokes, they're not actually jokes. They actually intend them to be taken literally. So Josh Smith asked them if Gas the Kikes was a joke. Peter Simi said, no, there's no jokes about Gas the Kikes. So then Josh Smith asked him, well, how many, in the last 25 years since you've been studying white supremacists, how many kikes have you known to be gassed? Josh Smith actually asked it just like that. It's in the court transcripts. Peter Simi said, what, excuse me? Roberta Kaplan immediately objects. She's not even making objections for basis anymore. Normally you have to make objections on basis. It's duplicative, asked and answered, it's harassing, it's lack of foundation, etc., etc. She's just now just whining and sometimes saying, Judge, come on, Judge. She's not even making a proper objection anymore. This is late in the case in chief, by the way. Peter Simi doesn't want to answer, and Josh says if it's meant to be taken literally, and they make all these jokes that aren't jokes about gassing the kike, surely some kikes would have to have been gassed. And the judge, Peter Simi doesn't want to answer because he got caught, right? And the judge, in his 85 years old southern accent, says, go on, answer. How many kikes have been gassed? There's a news article about it called Why a Federal Judge Said Gas the Kikes and How It Matters, or something along those lines. So that's Peter Simi. The defense begins. Let me back up. The case in chief by the plaintiffs was nothing but post after post after post from Discord, Twitter, Facebook of examples of quote-unquote racism and anti-Semitism. There was some discussion about being attacked by Antifa, things of that nature, but it was mostly just right-wing bants. Okay, Richard Spencer characterizes it crude, immature, tough talk, etc. Richard Spencer really tried to distance himself from this phase of his life. Some people did, some people didn't. You know, make of that whatever you want. But there's really never any hardcore evidence of a conspiracy. There's people planning to have a rally, people assuming Antifa would be there and that fights might ensue as they have in other rallies and marches and things where Antifa was present. And then a bunch of racism. There was a distinction here between conspiring to do racially motivated violence and conspiring to do violence while being racist, or conspiring to do anything while being racist for that matter. And the lines were intentionally blurred by the plaintiffs. And the big picture of what was going on here was never really allowed to come into court. So anyway, defense puts on a short case. They didn't have anything new to introduce. A lot of people criticized them for putting on such a short case. A lot of these, what do they call them? Fifth quarter inning quarterbacks or something like that. Fifth inning quarterbacks or fifth quarter. I don't know what the term is. Armchair quarterbacks when you're yelling at the TV. The people who aren't lawyers were opining a lot on social media. There wasn't any new evidence to bring out because once a witness is examined, the other party gets to cross-examine them. So every time, somebody like Heimbach was on the stand, his attorney, he was examined by the plaintiff's attorneys, and he was allowed to kind of tell the rest of the story by his own attorney. Something interesting that happened throughout this whole time, anytime, now this is quote-unquote lawyering, but it's also, you know what I think on it. Anytime there would be an answer that one of the defendants would give that one of the attorneys did not like, they would ask the record to be stricken of the answer, or for being non-responsive or something like that. And the judge played along at first, but then he kind of got tired of it and stopped letting him do that. And there were some interesting things that came out as a result. That was one of the many little tricks they tried to play. Another trick they tried to play would be they would introduce video without context. For example, they introduced the video of DeAndre Harris getting beaten, but not the immediate second prior of him just clubbing an old white guy from behind in the head, knocking him out on the pavement. That happened over and over and over again. Or, one of these guys, the defendants would give an answer that they didn't quite like, or it was a little too close to the truth of what actually happened, and they would ask for it to be stricken, things like that. And then their attorney, the defense attorney, would have to argue to the judge that it was proper and it was responsive, and it should stay on the record. I found a lot of the acts, a lot of the fake indignation Roberta Kaplan put on, I found insufferable. Karen Dunn always was operating at 11. Shrill, nasally, nasty. Found her insufferable. Who came across as the most contemptible to me would be Michael Block and Alan Levine. They had this tough guy act where they would say things like, "Isn't this exactly what you wanted?" About street fights to Michael Hill and Michael Block to Richard Spencer. "Wasn't this an alt-right declaration of war? It was, wasn't it?" And they would put on this tough guy act, and they stood there, these small frames, weak, hunched posture, frail and sickly looking, surrounded by a squadron of bodyguards anytime they left the courthouse. They had a huge security detail that was like Secret Service-esque. And they would put on this tough guy show in the courtroom, and they were just these frail, sickly looking Gollum-esque figures, pale and gaunt, totally unintimidating. In any normal society that wasn't a courtroom in latter-day United States or perhaps Tel Aviv, they would have no business speaking to anybody in such a manner. But they've been emboldened by this bloated and corrupt system that elevates people like them to the upper echelons of society instead of in the shuttles where they belong. And seeing that up close, it was one of those things where I woke up thinking, I can't possibly dislike them anymore. And I went to bed thinking, holy shit, I dislike them even more. Levine at one point went on at length about the 14 words coined by now deceased David Lane. He argued that the 14 words, the idea of wanting to secure a future for white children and the future of the white race is inherently anti-Semitic. Just facially, textually. You don't have to bring in the fact that Alan Burr conspired to, David Lane conspired to kill radio station hosting it by the name of Berg, Jewish fellow. Just textually. Wanting to secure a future for white children is inherently anti-Semitic, was the argument. I found that interesting because it was a tacit admission that the challenges faced by white society and the unsecure future of white children in this current juncture must necessarily be Semitic. You know, it was one of those mask slip ordeals. Anytime there was a mention of Israel being an ethno-state, there's a video of Matt Heimbach and Matt Parrott burning the Israel flag in the Talmud, or somebody burning the flag in the Talmud. They got very incensed, very enraged, as if it was almost as if at times they were on trial for such transgressions as burning the Israeli flag, not for anything that transpired in Charlottesville those 2 days. There's a lot of interesting things. The chants of Nazi scum off our streets, whose streets are streets, that sort of thing, were characterized as joyous and peaceful and jovial, and these were evil people, you know, chanting Antifa chants. So let's get to the verdict. Count 1 and 2, the KKK acts, no verdict returned, hung jury. Third claim, civil conspiracy, all defendants guilty, across the board. I find that interesting because some of the people here, like Robert Ray, who goes by Asmodor, Elliot Klein, Vanguard America, they didn't put on any defense whatsoever. So some of these people already had default judgments against them for not participating at all. They were found equally as guilty as people like Jason Kessler, who put on a defense, and people like Matt Heimbach and Matt Parrott, who put on a defense with an attorney, and Richard Spencer and Cantwell, who put on a defense on their own behalf. So there didn't seem to be a distinction made here between whether they participated whatsoever in the trial, represented themselves, or had an attorney. I just find that fascinating. I don't really have many thoughts on that. I don't know what the jury could have been thinking. I'm not really going to opine on what they could have been thinking. It's just an interesting aside. So count 3 is the one with all those underlying claims, tort and crimes I read to you. They gave Elizabeth Sines and the weird, creepy Reverend Seth Wispley $0. So they found that their injuries of PTSD were worth nothing. They gave everybody else $1. They found that their suffering, that their emotional distress, the fact that Devin Willis was surrounded at the Torch March rally and allegedly called the N-word, and that Seth Wispley was originally called a F-word. They said that's not worth much. Get out here, take your $1, go get yourself a Frosty and get the fuck out of the courtroom. Now those are compensatory damages, which are meant to make a plaintiff whole, and they've been damaged. Now comes punitives, which are a punishing mechanism. Punitives are generally awarded when a defendant engages in very egregious behavior. Think of, like, a cereal company knowingly putting arsenic in someone's cereal, or like repeated violations of something that they've been taken to court for. It's meant to be a punishment. Each individual defendant for Claim 3 was hit with a punitive of $500,000. The 5 organizations, Vanguard America, League of the South, Identity Europa, TWP, and NSM, were all hit with $1 million. I'll get back to that in a minute. Fourth claim, the ethnic racial harassment. That was entered in against all 5 of the defendants, Kessler, Spencer, Klein, Ray, and Cantwell, against 2 plaintiffs for $250,000 each. And then each defendant was hit with $200,000 punitive. The other claims were just against James Fields. He was found liable of hitting people with the car and the intentional infliction of emotional distress. They calculated some damages, a couple $100,000 apiece. But then his punitives were $6 million. Again, I don't know what to make of it. It's just an interesting footnote I would like to tell you. $6 million in punitives. Let's talk about the total damages a bit. He got hit with $6 million twice. About $1 million, $2 million in compensatory damages. Now these plaintiffs, via their attorneys, were seeking $3 to $5 million for each plaintiff not hit by a car and $7 to $10 million for each plaintiff hit by the car. So they were seeking $70 million. They get a total of $25 million. 13 and some change of that is James Fields. Unless he had an insurance policy that somehow would cover these millions of dollars, which I can't imagine he does because most policy limits are like $1 million. I doubt he had any assets, and I doubt he had any umbrella coverage. So unless he has assets somewhere, or unless he had some umbrella policy, which most people who aren't wealthy don't have, that's just straight up not collectible. He's facing 419 years in prison. They'll be able to take 15% of his commissary. So whatever money he earns, 15%, it depends on the state and where he's at. And there's laws that when people who are incarcerated owe money for things like this, they're allowed to, the people who are aggrieved are allowed to take a certain amount of money from their commissary, but it's limited. At most it would be 50%. So, and it depends on state statute. I shouldn't have even said at most it would be 50%. I don't know. It's like a percent, okay? But it's not the whole thing. You're not allowed, even if someone's in prison, you're not allowed to take all of their money. So if he has a job in prison, or if he has family or friends that put money on his books, the plaintiffs will be able to get a percentage of that every month. It's not going to be much. Let's go to these other guys. Something interesting happened with a punitive issue. There's a case that went up to the Supreme Court 20 years ago called State Farm versus Campbell. And what it said is that punitives aren't allowed to be excessive or compensatory, and here's why. Let's say somebody's damaged to the tune of $10,000. You're not allowed to turn around and order punitives of millions and millions of dollars because the Supreme Court said it violates the defendant's due process right. It's basically an unfair transfer of wealth from one party to another without a legal basis. So compensatories are compensatory. The person was damaged. This is how much money they were damaged. This is how much it'll cost to make them whole. Write the check. Okay, we get where that came from. You have a trial about it. You introduce the evidence of the cost, of future cost. It's there. It makes sense. Punitives can be just willy-nilly. They can just be made up. Like this $500,000 amount in punitives for each party, the jury literally just picked that out of thin air. So because jurors were picking that out of thin air, the Supreme Court said, this doesn't feel right. You shouldn't, just because somebody has money or because you don't like them, you shouldn't be able to punish them financially without really due process, because there's a due process of how you calculate, compensatory and award those, but there's no process of how punitives are awarded. So it has to be a certain ratio, if you will. And what that ratio is found to be is like 3 or 4 to 1. So what's going to happen now is the defense attorneys are going to put in a motion to have the punitive damages put in line with a proper ratio to compensatories. Compensatories were $1 for a lot of these guys. So that means the punitives, if calculated correctly according to this Supreme Court case, should only be like $3 to $4. So Matt Parrott, Matt Heimbach, Nathan D'Amigo, Michael Hill, Michael Tubbs, Jeff Scoop, maybe is Jeff Scoop on there? Jeff Scoop. And some of these organizations who are hit with these $500,000 and $1 million punitives, those should all get drastically reduced. Now, of course, the plaintiffs will fight this tooth and nail to ensure it's not reduced, but they should be reduced if there's any semblance of justice here. Now, because Richard Spencer, Jason Kessler, Elliot Klein, Chris Cantwell, and Robert Ray Asmodor were hit with additional compensatories of $250,000, that's not available to them because their punitives are within that ratio to the compensatory. They do have an appealable issue, I believe. I'm not their lawyer, this is just an opinion, as a third party. They were convicted of that count 4 of racial harassment, but it wasn't a conspiracy claim. So what that means is that all 5 of those defendants individually committed racial or ethnic harassment or violence against Devin, Willis, and Natalie Romero individually. I don't believe there was any evidence put on that ever happened. So if they appeal that, and that were to get overturned, they could then adjust their punitive damages to meet the compensatory damages from Claim 3 and owe almost nothing. So there is a scenario where this works out, where all these guys have to write a check for about $70. And that'll be all they end up getting. They won't collect the money from James Fields. A bunch of these punitives, so the punitives, this is $1 million in punitives, $6 million, 7, 8, 9, 10, 11, 12. So the other half is pretty much all punitives. So there is a scenario that plays out over time where James Fields not collectible. The $12 million in punitives all get wiped away to be like $10 a piece. And they end up with a few $100. I don't know if these people are going to pursue it. I don't know if they're just going to declare bankruptcy. I don't know what any of them are going to do. But that is something, that's out there. The aftermath is this. These laws, everything here is already on the books. There's not necessarily a new precedent in the sense that we can do these things, that these people like Kaplan and IFA can do that they couldn't have done before. This was always kind of out there. And things that happened to some of the Klan and those groups in the 60s is arguably more egregious than what happened to these guys here. But much like the 60s, we are in this era of extreme racial tension and people at each other's throats in this lawfare, and it's not so much to me a legal precedent as it is the political era in which we live. We live in an era of lawfare. We live in an era where if you stick your neck out, somebody's coming with an axe for it. And we live in an era where people will donate tens of millions of dollars to fund a lawsuit like this, to tie people who are advocates for the white race up for years, to try to bankrupt them, to smear them. Richard Spencer said the whole trial felt like character assassination, and to a degree, I don't agree with him on much, but I agree with him on that. So there was another article that said, I didn't confirm it on the 990s, but there's an article that said they spent about $40 million on this to get a $25 million verdict, most of which is not collectible. So then you start to wonder, well, your ROI was so bad. Was the point really ever the money? I don't think so. I think we are in an era where these people who are very well funded, very well connected, will just launch these lawsuits. There's a lot of things the defendants did wrong. The planning of Charlottesville. The execution really wasn't much of their fault, but the planning was. Statements made after were their lack of participation early on in the lawsuit was problematic. There were sanctions on things like discovery, numerous sanctions where some adverse inferences were granted. That's kind of a technical issue. It's not really here nor there. It didn't end up being material to the case, to the outcome. We live in interesting times, and I think this case, it looks like they were using this Klan law against Trump and some people for the January 6th deal. I don't know how they're going to claim that's racially motivated violence or not, or how they will claim that's racially motivated. That's beyond me. One thing I think that hung the jury on the first two claims was Christopher Cantwell represented himself. He's incarcerated currently, represented himself, did a very nice job. He learned very quickly. So I was impressed about how quick he was learning the legal process in the courtroom. He brought up over and over and over again that the violence that they talked about was against Antifa. And the plaintiffs went to extreme lengths to separate themselves from Antifa, to say that they were not Antifa, they were not participants of Antifa, they did not have friends who identified as Antifa or were part of any Antifa organizations. There are Antifa organizations. Like, Antifa is this broad idea, sure, but there's also organizations. It's like white nationalism is an idea, sure, but there are groups who are also white nationalists that you could join. Or you could just be a white nationalist yourself. Like there's this idea that you can't be Antifa because it's just an idea. It's like, okay, if somebody said, Rich, are you Antifa or are you a white nationalist? Well, one is it's obvious I'm one and not the other, right? Like if somebody were to describe me or my politics, I don't particularly use the label white nationalist, but just because it has connotations, but it's like, do I believe in a homeland for white people? For all the distinct white ethnicities, do I believe they should be able to retain their ancestral homelands and be in total control of their future? Yes. Okay. Does that make me Antifa? No. Does that make me a white nationalist? Yeah, I guess so. Right? You know what I mean? It's like one of those things. And so Christopher Cantwell hit many times on the point that, well, I was planning there to be violence with Antifa. And if you're claiming these people aren't Antifa, then how did I conspire to harm them, for one? But also, most of the people in Antifa that were in Charlottesville were white liberals. So how did I conspire to do racially motivated violence against white liberals who were Antifa? It was based on their ideology. And I think that hung the juror. That might have been what hung the jury on counts 1 and 2. If I were to opine on why the jury did and didn't do what they did. I'm sorry it ran so long. That is my presentation. Let me look at some if you had any comments or questions, I probably didn't see it. Let me take a look if there's anything on entropy. Viewers, no entropy. So, okay, that is my presentation. If any of you have any questions, post them here. If you would like to send any donations, you can do it the entropy or, oh, you already posted that, thanks. If you would like, I'll tell you what's going on. Yeah, so if you want to, yeah, sorry. Oh, I don't know. I don't see the entropy, Gadius. I wonder if I did something wrong here. Oh, I see a couple now. Oh, okay, Unknown California, thank you. Exoseat, thank you. And then Gaddy said, how do they prove any of these organizations are actually organizations? Do they have to be legally registered or something? I think all the groups that, let me look at the list here. I don't think it was ever in dispute that like National Socialist Movement, Trad Worker Party, Identity Europa, League of the South, and Vanguard were actual organizations. So I think all of those had some sort of legal designation as either forming, like in the case of TWP, they had documents filed for a political party. I think the other ones all had some sort of LLC or business entity formed. So they didn't. It was never an issue. If you did just have a group of friends, you could have a conspiracy between friends that doesn't have to be a part of a group. Just like with RICO, you can have like a criminal organization within an organization. So, but it wouldn't be charged separate. It wouldn't be like stipulated that they get charged separately. The only reason they did that, I think, is because they thought some of these organizations might have had some money or assets. So that's where they brought them into the case.